Welcome everyone. This video is on resolving a civil dispute. It is part of Legal Studies Unit 3, Area of Study 2, the Victorian Civil Justice System. So why is resolving civil disputes important? This is because civil disputes happen every day. They range from million-dollar contract disputes between multi-billion-dollar companies to petty neighbour disputes. So it's not just important for lawyers and those in the legal arena to understand about them, but it's important for everyone to know about them because chances are you'll be involved in one someday. In this video, we will be covering the purposes of civil pretrial procedures, alternative dispute resolution methods, reasons for the court hierarchy, and remedies. It's important to note that this video is an outline of some of the main topics in this area of study, but it doesn't include all of them. So you will need to use some other resources in order to have a full understanding of the whole topic. To start off with, the purposes of civil pretrial procedures are mainly to encourage an out-of-court settlement and to make the trial go faster. So with an out-of-court settlement, courts get very busy and waiting times are getting longer and longer. And even if you go to court, the process can be really drawn out by the lawyers and all the formalities that the court has to go through. It's also really expensive going to court because you have to pay for legal representation. So if you can come to an agreement out of court, it's better for everyone. Your dispute will be resolved in less time for less money, and you'll help free up the court's resources. However, if the parties cannot agree to an out-of-court settlement and the matter does go to trial, civil pretrial procedures try and make that trial go faster. So how does it do this? One way is through pleadings. Pleadings are documents that detail what each party is arguing and what they want. So for example, if I believe that you, my neighbour, has trespassed on my land and damaged my property, I can send you a letter of demand arguing that you have done this and that I want $5,000 as compensation. Another way is through discovery. Discovery is a process where the parties put forward the evidence they have against each other. They do this before the trial starts. So you know how in movies a lawyer will surprise the court with a piece of evidence which miraculously proves that the accused is guilty? This doesn't actually happen in real life. The parties know what evidence is going to be presented in court against them before the trial begins. So these two, they help enable the parties formulate their case before the trial begins and allows the actual trial to go a lot faster. Next up, we have alternative dispute resolution methods. These are ways of resolving disputes that do not involve going to court. So again, they're cheaper and quicker. First, we have mediation. This is very friendly. The parties resolve the disputes themselves. The mediator will facilitate this conversation they have with each other, ensuring that both parties have a chance to speak. But apart from that, there aren't really any strict rules to follow. It's cost-effective and quick, and it's used when the dispute is small and usually where the parties know each other. Next, we have conciliation. Here, the parties still resolve the dispute themselves, but the conciliator will make suggestions along the way. There are still no strict rules of evidence and procedure, but usually the disputes will be more complex than with mediation, so guidance is needed in order to reach a common resolution. Finally, we have arbitration. Arbitration is sort of like a mini court, which is why I put a boss baby down the bottom there. Here, the parties will put forward their case in a courtroom-like environment, and the arbitrator at the end will weigh up each party's case and make a binding decision in favour of one of them. There are stricter rules of evidence and procedure than for mediation and conciliation, and the disputes are more complex. All right, moving on, we have reasons for court hierarchy. Firstly, we have administrative convenience. Essentially, this allows the courts to more efficiently use its resources. A really simple example is that trials and hearings that take place in the magistrate's court don't use juries. So they don't use juries because they're so minor. So there is no need for that court to go through the process of impaneling a jury. Secondly, we have specialisation. Because similar cases are heard in the same court, judges and magistrates can specialise in certain areas of law, meaning that instead of judges having an in-depth knowledge of every area of law, they can have a focused expertise in a few areas. This is similar to administrative convenience, but the way that you can differentiate the two is that administrative convenience focuses more on those who work for the court and who help out, whereas specialisation is more about the judges and the magistrates. Thirdly, we have precedent. The court hierarchy allows for this doctrine to operate. It's an important concept and it comes up a lot, especially if you go on to study something like law. So it's worth taking the time to wrap your head around it. But basically it means that decisions made by higher courts will be followed by lower courts when deciding on cases with similar facts. So it's sort of like a guidance. If there was not a court hierarchy, each court would be on the same level, and following and setting precedent would be messy. Courts wouldn't know which decision they were bound to follow, for example. Finally, we have appeals. Everybody makes mistakes, including lawyers, judges, and juries, so we have to have a safeguard. The court hierarchy allows for higher courts to review decisions made by lower courts to hopefully rectify any mistakes that are made. All right, so the last bit of content for this video is on remedies. And the two we focus on are damages and injunctions. When you think of damages or when you see damages, think of money. They involve one party paying money to the other. They aim to compensate the party getting the money and punish the party giving the money. So in the example I gave before, where I take you, my neighbour, to court about trespassing on my property and damaging my property, I could attempt to get from you the money that I think I need in order to compensate myself. So if I think that you did $5,000 in damage, I would seek to get from you $5,000 in court. The other remedy is injunctions, and these are usually used when money won't help. They either stop someone from doing something or make someone do something. So in the same example, when I take you to court for trespassing on my land, I can try and seek an injunction which stops you from trespassing on my land. So it forbids you from going on my property. Okay, so that ends the content for the video, but I also want to cover how to answer questions in legal studies. Learning this is just as important as learning the content because it allows you to answer questions quicker, clearer, and in a way that your teachers and exam markers will love. So the formula is TEAL. It stands for topic, explain, apply, and link. T for topic introduces the main idea of your paragraph, and it will often be that you are using the wording of the question in this sentence. E for explain means that you give further information about the main idea. A for apply means that you give an example or some piece of evidence. And L for link means that you connect what you have said back to the question. So here's a question that exam markers love putting on the end of your exam or something similar. It's, what is one reason the Victorian justice system has a court hierarchy? You may like to pause the video now and give it a go yourself before I give my example on the next slide. So here's one that I put together. T for topic, I introduced the idea. One reason for the court hierarchy is to allow for appeals. You'll notice I also use the wording of the question in this sentence. Then I explain what I've just said. The court hierarchy allows for a decision in a lower court to be reviewed in a higher court. Next, I apply it by giving an example. For example, if a party believes she has been wrongly convicted of an offence in the county court, She can appeal the decision to the Supreme Court. Doing this shows that you truly understand the content, and exam markers love to see it. It's a great way to pick up marks. Finally, I link my answer to the question by saying, therefore, one reason the court hierarchy exists is to allow for the operation of appeals. And just like that, you got 3 marks in the bag. As easy as that. That brings us to the end of this video. Thank you for listening. I hope it was helpful, and best of luck for the year.